Right now in the Constitution, the Crimes Act, the bulk of the stuff we deal with police is at a state jurisdictional level. Let's say the Voice has something to say about the juvenile detention or the rates of Aboriginal people in jails, and it makes a recommendation or gives its representation, advice the PM might want to call it, to the government, and the government decides to move on it, or the High Court imposes that on the government, then you could find the Commonwealth legislating about policing or about jails in a sense that that's previously been a state area of responsibility. Is that what you're talking about?
I think it does have that potential, because the Voice's function is to make representations on matters relating to Indigenous peoples, and plainly laws of that nature relate to Indigenous peoples. And so this broad use of connecting language that's being proposed, a power to make laws with respect to matters relating to the Voice, could therefore open up this power to legislate to implement the recommendations of the Voice. Look, it could be read more narrowly. People could say, well, look, the intention is that the power is to legislate in relation to the composition of the Voice and its procedures. In other words, the institution of the Voice itself. But the problem is that the High Court has insisted that it doesn't pay attention to subjective expectations, but it looks at the language that is used. And it doesn't read down the language in, granting power to the Parliament to legislate by reference to trying to maintain a federal balance between the Commonwealth and the states. It interprets the language as widely as the words used can reasonably sustain.
Louise Clegg, how concerned are you? I know you've spoken about a lot of the legal unknowns with the Voice, but we're having this debate now. It's gaining traction now, and as of yesterday, Australians are already out there casting their vote.
It's extraordinary, Peter. Pretty much unheard of. In previous referenda, we've had constitutional conventions and platforms provided to lawyers, and not just lawyers, but anyone who wished to contribute and dissent. But that just never happened in this case. At the Garma festival last year, the Prime Minister put forward the words that are pretty much what we have now. And as Nick just explained, if anything, the proposal has become bigger and more powerful. He said then that there would be opportunity for people to get involved in having a say on it, but that opportunity was never given by the government. There was an inquiry, an parliamentary joint select committee in April, but by that point, the bill had already been crafted and was sort of sailing through Parliament. And even then, a lot of people on the no side and a lot of lawyers on the low side considered that to be a bit of a sham, to be honest, because it only lasted for about 2 weeks of hearings, whereas in previous referenda, those sorts of processes had often lasted months. But even worse, the hand-picked lawyers of the Constitutional Expert Committee were sort of paraded through early and gave oral evidence to the committee. And this was while the very eminent and quite a few eminent retired judges and Nick and his colleague Peter Durangelos were making their written submissions, and they never even had an opportunity to address the committee about their very serious and much broader concerns than the committee was dealing with. So the fact that this has come up now is a very major issue, an issue that should have constitutional law academics and practitioners all around the country pouring all over it, is extraordinary when, as you say, people are off to the polling booths.
Professor, what about the risk that the Voice could actually take the government to the High Court if it feels it hasn't been consulted enough on an issue that it feels relates to or affects Aboriginal people? Take us through this risk and what it would mean to our system of government if that's in fact the reality.
So, Peter, the constitutional amendment has to be read in the context of the Australian legal system as a whole, and lawyers refer to a body of law called administrative law, and under that principle, whenever a government or executive decision maker exercises a statutory power, makes a decision, exercises a power, they are required to take every mandatory consideration into consideration and not take irrelevant considerations into account when making that decision. Now, if a person aggrieved by that decision believes that the decision maker failed to take a mandatory consideration into account, they can seek to initiate proceedings in a court, asking the court to quash the decision, to nullify the decision, and to require the decision maker to go back and make the decision again, properly taking into consideration what it should have taken into consideration. And so the interesting question is, by amending the Constitution to give the Indigenous voice the power or the right to make representations to the executive government, noting that the Constitution is superior to the statutory law and the common law, it's quite arguable that this would be interpreted by the courts to mean that representations made by the voice on matters relating to Indigenous peoples would be mandatory considerations that must be considered whenever a decision maker exercises a power. And that would trigger these administrative law remedies, which, it has to be emphasised, are exercised all the time. But that's how, or that's one of the practical effects, as it were, of the proposed constitutional amendment that I think is worth bearing in mind.
I know it's late in the day, Nicholas Roney, but you do your country a great service by putting pen to paper and putting out this research paper, at least this side of the vote now in 10 days' time. Louise Clegg, thank you. Your advocacy has been pretty extraordinary on The Voice as well. Both of you, I appreciate your time tonight. Professor Nicholas Roney there and Louise Clegg.